what is the difference between a request for evidence and a notice of intent to deny, and why does an adjudicator pick one or the other? Well, historically, RFEs have been way more common than notices of intent to deny, and an RFE you got a lot better chance of bouncing back from. So the RFE means that the adjudicator is open to being persuaded that you deserve to win. You get that 84 day period to get together whatever further evidence and arguments that you want. And if you paid for premium processing, the clock pauses when the RFE is issued. It resumes the day they get your response. And then they'll give themselves a whole new period to adjudicate. Notice of intent to deny is a much shorter period. You got that 33 days. That makes it more intense to get everything together. A notice of intent to deny also indicates that the adjudicator is really not feeling what you're selling, and your chance of winning is lower than if you just had a regular RFE. Like, you haven't made the case. I mean, either way, you haven't convinced the officer. So the actual process of answering is not that different other than the time frame. But the notice of intent to deny is more concerning. They're both something that is concerning. It's not a time to get hysterical, because it doesn't mean you can't win. You absolutely still can win. It's not a time to give up unless your lawyer says, hey, this really seems unwinnable. You may, depending on what kind of case it was and what your immigration situation is, withdrawal is an option that some lawyers will advocate for if they think that it's that your chance of winning is really tiny. But in general, in this era, across all case types, we're going to see a lot of RFEs. There are going to be a lot of NOIDs. Don't give up. It's not the end of the road. It does take careful planning. And another thing that I really wish people who got an RFE could see a nice sample set of everyone else's RFEs, because I think you can get it and think, oh my gosh, my lawyer did everything wrong. I didn't prove anything. Like, they didn't, see what I sent, and they didn't understand. And, it's full of all this boilerplate language. It's full of a lot of boilerplate language that doesn't necessarily apply to your own case. And they're also really, really long. Your lawyer can really help you boil down, like, what is the RFE for? Like, what are the weaknesses? What are the parts that we successfully satisfied them on? And what are the parts that we still have more work to do? And even though your RFE might be 6 or 8 or 10 pages long, it's actually much more concentrated, like what you need to do now to get that path to win. It's normal that you work with the same attorney that filed your petition. If you filed the petition on your own and you need to bring in an attorney, you can try to hire one. A lot of attorneys are not really excited to jump in to somebody's case in the middle when they didn't have control over what was already filed with the petition. But some are. And, every RFE, no matter how simple it seems, it deserves a really careful response, because this is your chance to salvage your case and get to the win. So good luck.